Work. Hey, work, work, work. Can you work yourself to death? Well, that takes us to this week's case. Involves a real couple in Pennsylvania. And there was a man named Robert Diaz. He suffered a death, died of a heart attack. When he died, his widow, Judith Diaz, brought claim under workers' compensation in Pennsylvania, contending that essentially he worked himself to death. She pointed out that during his job life, he worked very hard, strenuous jobs, over 40 hours a week, doing such things as operating a jackhammer and various other things that required real, strong work. Well, she brought her claim. And when she brought it before a workers' compensation judge, the employer on the other side of this argued, no, no, no. This is not a result of work. This is simply a result of a poor lifestyle. Robert Diaz smoked over a pack of cigarettes a day. He lived a very poor lifestyle, and even though he died at age 48, that was a natural result of the kind of lifestyle that he lived. His wife continued to argue through her attorney that no, it was the kind of hard work that he was doing over 40 hours a week that produced his death. Well, the judge at the Workers' Compensation Board decided that, in fact, the employer was right and decided that she was not due benefits. The case was appealed. It went up to the Workers' Compensation Appellate Board. And there, the board heard the various arguments and came away also saying, Mr. Employer, you're right. This was a natural cause of death, and as a result, there was no claim for death benefits under the Workers' Compensation law. The case was again appealed, and this time it went up to a court for the Commonwealth of the state of Pennsylvania, and the court there looked at the evidence, and came away at this point in time saying, we now agree with Judith. And we find that, in fact, the death of Robert Diaz was caused by and related to his employment. The kind of work that he did, in fact, did produce his death, and therefore Judith Diaz is entitled to a workers' compensation benefit for the death of her husband. Okay, so what do we learn from this case? The important thing we learn is that even though a death might seem to be natural in nature in the sense of a heart attack, if in fact there's sufficient evidence that demonstrates that heart attack was precipitated by the activities incumbent in the work that was done, well then, in fact, it can be found to be a workers' compensation claim, and death benefits are due. Okay, we bring you this case, we bring cases every week so you understand how the law works. I'm David Allen.